and we're following UACAVA, which is a federal law, and its state law counterpart. And UACAVA has basically been described as the manner and method by which voters who reside overseas, as well as voters who are members of our armed forces or their dependents and spouses, have protection in connection with elections. This is a quote from the United States versus the state of New York, which is a federal case from 2012 that I think addresses this issue. And again, it says that nothing, this is from a court order, the judge had said that nothing is more critical to a vibrant democratic society than citizen participation in government through the act of voting. And it is unconscionable to send men and women overseas to preserve our democracy while simultaneously disenfranchising them while they are gone. So, in brief, what is UACAVA and how does Florida comply with the law? The UACAVA is a federal law that provides certain voting rights and protections to members of, again, our uniformed services, their dependent family members, and U.S. citizens residing outside the United States. The rights afforded to these voters include the right to obtain their vote-by-mail ballot 45 days before certain federal elections, and then specifically for overseas voters, an additional grace period whereby they can return their ballot on or before Election Day, and it must be counted if it is received by the Supervisor of Elections up to 10 days after the election. Now, Florida has its own statutory provisions to comply with UACAVA that mimic UACAVA. The first question for the canvassing board in its consideration of the ballots you're going to be looking at today is, what is an overseas voter? And Florida law defines an overseas voter as an absent uniformed service voter who, by reason of active duty or service, is absent from the United States on the date of the election involved. And that is from the definition of overseas voter in the Florida Election Code. Additionally, a person who resides outside the United States and is qualified to vote in the last place in which they were domiciled before leaving the United States. Also, an overseas voter is a person who resides outside the United States, and but for that residence would be qualified to vote in the last place where they were domiciled within the United States. Overseas does not require there actually be a body of water between Florida and the location. Hawaii and Guam are not overseas, despite there actually being a sea, but Canada counts as overseas. So what additional rights does an overseas voter have to return their vote-by-mail ballot? Pursuant to Florida law and UACAVA, overseas, both military and civilian voters can either return a vote-by-mail ballot, a signed voter certificate by fax directly to their Supervisor of Elections, provided it is received no later than 7 p.m. on Election Day. And an overseas voter, using the definition that was previously described, has an extra 10 days from the Election Day to mail back their vote-by-mail ballot. The 10-day extension only applies to certain elections. Generally, it's a presidential preference primary election or a general election, but by operation of law in Florida, special elections and special primary elections also afford that 10-day grace period. So a vote-by-mail ballot from an overseas voter that is either postmarked or dated no later than the date of the election and is received by the SOE no later than 10 days after the date of the election shall be counted, as long as the ballot is otherwise proper. And the shall be counted comes directly from statute, and that is mandatory. So does the 10-day post-election grace period apply to all UACAVA eligible voters? It does not. The applicable statutes, both federal law and state law, specify that it is only the overseas voter component of UACAVA voters who are afforded an opportunity to have an otherwise timely vote-by-mail ballot received up to 10 days after the election. You will be presented with ballots and information today for your consideration. So what are some of the kinds of evidence that the canvassing board has the ability to consider to determine whether a ballot is from an overseas voter? Example one is the voter has registered to vote and checked the box indicating they reside overseas. If only a stateside address is provided, there must be some other indication in the voter record or otherwise presented to the canvassing board that the voter was in fact overseas at the time of the election. How about the voter has requested a vote-by-mail ballot to be sent to an overseas address? That is evidence that the voter was overseas at the time of the election. that there's other evidence in the voter file that the voter indicated that they are or will be overseas at the time of the election. The ballot bears a postmark showing that it came from outside the United States or has other indicia that it was received from outside the United States. There may be other factual information that can be provided to the canvassing board that the voter was overseas at the time of the election, and if by majority vote of the canvassing board it is elected to consider that information, it may in fact do so. It is important to note that the mere fact that a voter has indicated that they are an active uniformed service member or a dependent spouse of a service member is not evidence that the voter was overseas. Again, while they are covered and eligible for certain benefits under UACAVA, the 10-day grace period, again, only applies to overseas voters. So, when you are evaluating the date on an overseas ballot, Florida law requires that a ballot from an overseas voter, again, be sent on or before the date of the election and received no later than the 10th day after the election, which is today at 5 p.m. In considering whether a vote-by-mail ballot from an otherwise determined overseas voter was sent on or before Election Day, there is a statutory presumption that the envelope was mailed on the date that the voter stated on the outside of the return envelope in the voter certificate, regardless of the absence of a postmark on the mailed envelope or the existence of a postmark date that is later than the date of the election. So, in short, the statute expressly provides that you go by the earlier date, the date of the voter's signature or the date of the postmark. If it is on or before Election Day, either of them are on or before Election Day, then that vote is deemed properly mailed on or before Election Day. And lastly, I'd like to just discuss briefly the legal standard when considering a vote. If the voter file or other evidence that the canvassing board elects to accept shows that the voter is an overseas voter, again, that they were outside the United States on the date of the election, standard considerations for acceptance of a vote-by-mail ballot apply. And there are some quotes here from a primary case dealing with this type of issue, which is Boardman versus Esteva, a 1975 Florida Supreme Court decision. It is important to note that substantial compliance with the absentee voting laws is all that's required to give legality to the ballot. From a principled standpoint, a fair election and an honest return are the paramount items of importance over minor requirements which prescribe formal steps. In short, if there's a clerical or technical issue that does not result in a violation of the paramount items for the election, then it may be disregarded by the canvassing board. It is important to note that if you have determined that the voter was an overseas voter, if there is an objection, the burden is clearly on the contester to establish that the ballots have been irregularly cast. And if the canvassing board determines that a ballot should be counted and the ballot was cast by a qualified registered voter, there is a, quote, presumption of correctness in the decisions of the canvassing board. And unless there are any questions from the canvassing board on this issue, that's the last of my presentation. I'll return this to staff.
I just have one question.
Yes, Vice Mayor.
Slide number 4, can you put that one back up?
Yes.
Is that a verbatim of Florida statute?
That is a direct quote. The first 3 bullets where it defines overseas voter, that is in the definitions section of the Florida Election Code, quote unquote.
Here's my question on that, and I'm just going by my old law school memory, which is sometimes pretty dangerous. When there's an or between those bullet points, explain to me what bullet point number 1 means.
That first one means that the first category of folks that can be deemed an overseas voter would be somebody who is in the uniformed services, who by reason of their duty or service is absent from the United States on the date of the election. That is category number 1.
Okay.
If they are in the armed forces, for example, and they are outside the United States, they are an overseas voter.
So if you're a UCAVA voter, you requested your UCAVA ballot, you get your UCAVA ballot, and you're in the Army, you're not in the Navy, you're not overseas, and you're out on election, you're absent from the date of the United States on, I guess, November 2nd, are you an overseas voter?
If you are outside of the United States on the date of the election, you are an overseas voter. if you are outside the United States, not outside the state of Florida, not outside Broward County, outside of the United States.
Got it. Thank you.
Anybody have any questions?
Yes. Could we see slide 5 again?
Daniel, do you have copies for, that you could give one to each candidate?
I don't know if there are extra copies. Patricia, do you happen to have?